I wanted to talk to you about what you did yesterday in your discussion questions about the Supreme Court and public policy. These are things I would have been talking to you about if we'd been in class, but since we're not, I just thought I would try this new technology. I've never done it before, so please forgive me if it's a total screw up. This is actually the second time I've gone through with taping this, so I'm learning as we go. Okay, the Supreme Court and public policy. There were several of these answers that you guys all came up with on the Google Doc where you wrote your answers, and you did a really good job with that. Some of them you might remember from Hamilton's Federalist 78. They're appointed, they're not elected, they have lifetime tenure. Something else we haven't talked about yet, but I want to make sure you understand, is that the Supreme Court controls its own docket. Docket means its calendar of what cases it's going to take, and they have total control over that. They decide what they're going to take, what they're not going to take, what cases. They get about 8,000 a year of petitions, and they only take about 80. I think I misstated that in class and said they got about 1,000 a year, and I was off by a large factor. They get around 8,000 petitions a year, and they only take around 80, and they get to decide when they're going to hear those cases. Their salaries can't be reduced. That's in the Constitution, so they have no threat to their income. Also, the public has very limited access to the court and what they're doing. They have hearings that are public, and insofar as the media can be there can be maybe 150 people in the room when they're hearing the case. For most cases now, or important cases, they release an audio after the hearing of what questions were asked and what they were answered, and there are transcripts available, but there are no cameras in the courtroom. It's not like C-SPAN, and they refuse to add cameras, and it's just up to them that they're not going to have cameras. Then all their meetings are behind closed doors. When they meet to discuss a case, it's only the 9 justices in the room. They don't have any aides. They don't have anybody taking notes. It's just them. And so we don't know what gets said in those meetings. All we know is what comes out in the opinions when they're issued. My other question about it was why they won't deviate too far from public opinion. One part of the answer is the appointment and confirmation process. Even though, as I told you before, they won't answer questions about specific issues. This is sometimes called the Ginsburg rule because she was the first one. And so if a senator asks a question about what they think about affirmative action or abortion or any of the other myriad of issues that come before the court, they just say, Senator, I would like to answer, but since that could come before the court and I don't want to prejudge a hypothetical, I cannot answer that question. So we don't get their specific answers, but there is a moderating tendency that presidents usually don't want to go too far out of the mainstream and pick an extremist in who they nominate, and the senators feel the same way in whom they will approve. This moderating tendency's been lost a little bit now since we got rid of the Senate filibuster on Supreme Court nominees, but even so, there are enough moderates within the Republican Party, for example, that President Trump wouldn't pick a real extremist that he would feel might not get 50 votes. So that tends to moderate a little bit. Even after they're approved and they can't be fired, there's still some forces that keep them from getting too far out of line. For example, they cannot enforce decisions themselves. They have to rely on either the executive branch or the state governments to enforce those decisions. And they don't want their decisions to be ignored. That's what you read about in the article about Brown 2, that they said enforce school desegregation with all deliberate speed. And a lot of states did more the deliberate, which means doing it slowly and carefully, than the speedy part. And so they realized that they have to be somewhat in line with public opinion. They know that if they went too far out, there could be an amendment to try and overrule their decision. This is very difficult to do. There have been many attempts to try and have a constitutional amendment that would change some of their rulings, and it's very rare that it succeeded. One example is with income tax. In the 19th century, there were federal income taxes, and the Supreme Court ruled that Congress did not have the power to impose a federal income tax, and that's why we got the 16th Amendment. Sometimes when they're ruling on just a law and not a constitutional power, Congress or a state can rewrite the law and make it more acceptable. We saw that in the capital punishment cases from Georgia. They went back to the drawing books and they wrote a more acceptable program for how to decide who gets capital punishment and who doesn't. They're very concerned about the reputation of the court. There is a consciousness they have that if they seem too far out, the court loses respect, and there are dangers of people not accepting their decisions. I think that's one of the reasons that we waited a while before they ruled on same-sex marriage, that had been an issue for over a decade that was burbling up on the state level and in state courts and appellate courts, and it wasn't until 2015 that they went ahead and ruled on that. There is the potential for impeachment. That's the ultimate sanction. That's just a no-go. We have never had a successful impeachment attempt for a justice on the basis of what the justices ruled. There are people who talk about it, but it's not going to happen, so don't worry about that. Okay, concerns they have in enacting public policy. One, they realize they don't have the expertise, that a lot of things are very technical, so they tend to defer to the experts, whether it's scientists in environmental law, military when it comes to questions of national security. As we said, they don't want to get too far out ahead of public opinion. You saw that in Brown too. Federalism, they realize some things are okay within state powers that might not be okay within federal powers, and they recognize that. We saw that when Congress passed the Religious Freedom Restoration Act, that originally Congress had said that would apply to both the states and the federal government to use strict scrutiny and free exercise questions. And the Supreme Court struck down the part that said it applied to states. We've seen that with some gun laws where they strike it down applying to states. They're conscious of separation of powers, that they don't want to get in between debates between Congress and the president about who has the power to do what. Another limitation is that they only can take cases that come to them. They can't just decide, same-sex marriage is a problem that we need to resolve. Let's just go ahead and make a statement about that. They will not rule on anything until it comes to them as a case. In fact, early on in the 18th century, there were attempts by Congress to go to the Supreme Court and say, hey, we think we're going to pass this law. What do you think? Would this be constitutional? And the Supreme Court said, nope, we're not getting in that business. You pass the law, let someone bring a suit, and then we will look at it when we have facts on the ground. But we're not taking this avenue that Congress wanted to give them to say which laws would be constitutional in advance. The other thing is they don't want to interfere with political questions. We saw that when we talked about the mail apportionment cases. Remember Baker v. Carr? That we waited till the 1960s before the Supreme Court said we're going to step in and talk about whether mail apportionment is a constitutional violation. Just recently, when it came to gerrymandering in a North Carolina case, they said, no, we're not going to decide this. This is a political issue. It's not a constitutional issue. Okay, so those are some points that I hope you guys can understand about what the relationship between the Supreme Court and public policy and their role in enacting public policy. They can do it, and they obviously have done it in issues on the environment and presidential powers, the war on terror, abortion, healthcare policy, affirmative action, lots and lots of issues they have spoken about, but there are some constraints on what they can do and what they're willing to do. Okay, thank you.